For our case today, we have a decision from the Court of Appeals in the Sixth Circuit, Stephen Hank versus Greater Lakes Construction Company. This case is more of a note of practice tips, really, than for the substantive aspects of the case. We'll, of course, discuss the substantive aspects, but that's not really why I'm bringing this case to your attention. This case is more about tactics and strategy when it comes to how to handle appeals, and goes to why spaghetti at the wall doesn't always work and should be advised against. So spaghetti at the wall, lawyers throw everything at the case they think could even remotely apply. But courts don't like it because it throws very weak arguments, and it has a tendency of undermining your strong arguments. So when you make a lot of arguments, and some of them are very weak, it has a tendency of the weak undermining the strong arguments rather than the strong arguments buttressing the weak arguments. So the courts have a tendency of looking at the really weak arguments, saying these arguments are really weak, and tending to kind of ignore your stronger arguments. So as a matter of strategy, it becomes very important for a lawyer when he's deciding what to argue at a trial court or what to appeal on. Even if he has multiple lines of argument he thinks can work, it is advisable to bring them down into the stronger courses of action. So it becomes a tactical balance of what arguments to bring forth and what not, because you're always worried that the argument you didn't bring might have been the one that won. But this is why lawyers get paid the big bucks, because they have to make those strategic decisions and decide which arguments to bring forward. They have to decide what are the strongest arguments and abandon the weak arguments, and it becomes a real balancing act, but that's one of the things here. So this is more about the practice tip, and so we're going to read what the court has to say about why you might want to not throw everything you have at the case. So let's get started with this. This court once observed, when a party comes to us with 9 grounds for reversing the district court, that usually means there are none. Stephen Hank comes to us with 27. So you can tell from the first 2 sentences how this case is going to go down. The ending has been spoiled for you, right? We all know what's happening. You're not going to win. Hank's case comes at his termination from Great Lakes Construction Company. Defendants are Great Lakes and the union. Claims the termination was discrimination and retaliation. Great Lakes and the union claims it was because of falsified time cards. They also point out that Hank signed a release that bars the claim. Releases have various operative and legal effects. So just because you signed a release doesn't necessarily mean you're done. So, talk to a lawyer if this ever comes up, because you still might be able to press on. So the signing of the release, you could argue coercion, a whole bunch of stuff. So it's not necessarily dispositive. The district court agreed with Great Lakes and the union in grand summary judgment, and Hank comes to us with 27 grounds on which the district court erred. We find none of the grounds persuasive and therefore affirm. So yeah, I think basically what happened here is that they found many of the arguments to be weak, and even arguments that were arguably strong they kind of ignored, because it's like, well, these arguments are crap, therefore the whole thing is crap. It's the one bad apple of the bunch kind of problem. You have one bad apple spoils the entire batch. That's basically what happened here. So you had a whole bunch of healthy stuff, and you had some bad stuff, and the bad stuff just taints everything. So bad strategy. Don't do this. This is a practice tip to the wise. This is your case in point to say, if you ever have a client who says to you, why aren't you bringing everything? It's basically because because it won't work. That's why we have to be a little bit more judicious about our arguments. So yeah. Hank wanted more recovery time than Great Lakes was willing to grant him for an injury. He alleged that it takes 6 weeks to recover from the knee surgery, but Great Lakes only let him have 13 days of leave. Okay, that seems a little short. Hank came back to work only after a week and a half of unpaid leave and continued to have problems with his knee after he did. Going back to the Ohio Bureau, he requested Great Lakes cover his prescribed therapies for complications he experienced after returning to work, including gel injections and occupational therapy, and Great Lakes rejected these requests. Around October and November of 2015, Hank allegedly told a supervisor he'd be filing additional worker compensation claims. According to Hank, this is when Great Lakes started spying on him to catch him in some act that would justify terminating him. So going to a retaliation kind of theory. Yeah. Then on the 22nd of January 2016, Hank was called into a meeting. There were 6 other people in the room, 5 were managers, and the other was a union rep. The managers alleged that Hank had falsified some of his time cards, meaning he had been paid for work they didn't do. They presented Hank with time cards and offered to show him video surveillance surveillance, which allegedly showed Hank showing for work later than the time listed on the cards, and he declined to watch. Manitoban says, use your strongest, say 3 arguments. There's no categorical rule here, Manitoban, on like how many arguments. You should bring as many strong arguments as you have and nothing more. And if you have 10 arguments or 20 arguments or 30 arguments, it becomes a question of what are the strongest arguments. And this is one of the lawyer's responsibilities. The classic division of labor between lawyer and client is the client sets the goal to be achieved. The lawyer sets the method to achieve it. So you as the client tell me, what do you want? What is your goal here? What are you hoping to achieve? I'd like to be, not fired. I'd like to be compensated for being fired. I'd like to, have my whistleblower protection. These are the goals you want to achieve. Great. If I'm your lawyer, I am obligated to achieve the objectives you just asked me to do. That is my obligation. But my duty as the lawyer is to say how to achieve it. And that is my responsibility and my part of the puzzle. So I get to say how we go about achieving it. I get to say what papers I'm going to file, what documentation I'm going to file, what complaints I'm going to bring, what arguments I'm going to bring. And you say, hey, lawyer, I want you to bring this argument. I want you to bring that argument. I have the absolute right to say no. No, I'm not going to do those things. That's my call. I get strategic judgment over the case. I get to say how. You get to say what. I get to say how. If you don't like it, fire me. You can have the right to fire me, but you don't have the right to dictate me as long as I'm hired. It's very, very clear in the rules of ethics. I have a job. My job is to zealously represent your interests, perhaps in spite of yourself, because you might want to bring arguments that are going to kill your case. And it is my responsibility as your lawyer to figure out what arguments are going to be good for you and what arguments are not going to be good for you. You get to set the goals. I get to set the means of achieving the goals. If you're unhappy with the means of setting the goals, go find a different lawyer, because that is my responsibility, and you don't get to tread on my turf. So if I have 10, 20, 30 arguments I could theoretically bring, it's up to me as the lawyer to figure out what my strongest arguments are. That might be all 30. It might be one. There's no clear rule here. This is where the strategic and tactical judgment of the lawyer becomes critical. And it can very much depend on the specific judges that are going to be hearing things. It's very fact dependent on the case and what you think you can and cannot prove. And it's also dependent, not inconsequentially, on the lawyer's style and kind of what he's comfortable doing, because different lawyers have different kinds of ways of pursuing things. So what is the strongest argument is not necessarily objective. It can be dependent on the lawyer to some extent. So what might be the strongest argument for one lawyer may not be the strongest argument for another lawyer. And so these are the kind of tactical, strategic decisions that a lawyer can and must make. And you need to explain this to your client. And if your client is insisting upon it, you should tell your client, please fire me, because I'm not going to do it. If you want to find another lawyer, fine. You have the right to another lawyer. You have a right to a lawyer of your choice. But if you're choosing me, if I have the ball is mine. That's the key. That's the legal aspects here. So that's really good. And so thank you for the question. Really helps me explain that. So thank you for the question. And Newt UK also points out that it's even worse that a lot of time they're wrong about what they want. And that's also part of the lawyer's role as a counselor and advisor. So one of the things that a lawyer can and has an obligation to do is help to inform the client about things that they want, because a client, being so close to it, may not be able to see the broad picture. So they may be wrong about what they want. And so a lawyer has a right to help inform their client. They have a right to say, here's some things that you may not have thought about, here's some things you may want, and here's some things you may think, have you considered this, consider this, consider this. And so you have a right to do that. Now, at the end of the day, the client has the right to determine what they want. So if you can't get on board because your client, in your view, the client wants the wrong things, you have a right to say, well, I don't want the case. Lawyer's under no obligation to take a case. I'm not the right lawyer for you. I don't think these are the right arguments. I've tried to give you my best advice. I've tried to give you my best counsel. You're refusing my advice. You're refusing my counsel. It's like, I don't think it's the right case. Find a different lawyer. And, there's lots of different lawyers. And it could just be an issue of chemistry, too. Not every client gets along with every lawyer. It's a personal relationship as much as professional. You have to have confidence in your lawyer. And you have to have confidence in your client. And if you don't have synergy, that's fine. So yeah, the client may want the wrong things, and you as a lawyer can say, well, here's some things you should want. The client gets the ultimate ability to determine what they want. If you as a lawyer say, well, I can't do that, so I can't work for you, that's fine. And if the client says, well, I want you to pursue things and you're not pursuing them, so I'm going to fire you, that's fine too. That's the responsibilities. You get to determine what you want. I get to determine how to do it. We can both try to persuade the other, but at the end of the day, we both have our turf. And that is the rules. So yeah, no problem. The Great Lakes manager stepped out of the room to give Hank time to consult with his union representative, which they did. When the managers came back, they presented him with a release. The release reads in its entirety, the Great Lakes Company agrees that instead of terminating Stephen Hank for falsification of time records, it will instead place him on laid-off status with no right to recall. In return, Hank agrees he will not file a grievance under the collective bargaining agreement and will not pursue or file any sort of claim against Great Lake or Local 18. Mr. Hank agrees he will not seek reemployment at any time in the future with Great Lakes. The union agrees it will not pursue or file any grievance on the behalf. Okay, fine. So instead of terminating you for cause, we're just going to say that we're laying you off. Okay, fair enough. Hank allegedly asked for clarification, wanting to know the difference it made to be put on laid-off status. Great Lakes informed him that if he signed the release and took laid-off status, then he could get unemployment benefits. Yeah, that's the typical huge distinction. If you're fired just because you're laid off, you typically get unemployment benefits. If you're fired for cause, you typically don't get unemployment benefits. So that is a huge distinction, yes. Shortly after they signed the release and the meeting ended, sure enough, they placed him on the layoff status and paid him unemployment benefits. So he got what he bargained for. Okay, fair enough. About a week later, Hank filed a union grievance. In it, he alleged he'd been terminated because of his ongoing worker compensation claim with Great Lakes. The union reviewed the evidence against Hank, including the time cards and surveillance footage, and determined not to pursue the grievance because it had sufficient cause. Okay, yeah, so he's basically arguing coercion. I was forced to make a decision in a really prompt manner. I didn't really understand what I was signing. So there's some potentially valid arguments here that could be made. You know, it's difficult in view of the signed waiver, but it's not impossible. Okay. Captain Terrific says, White, why do you want to sue the union? Well, presumably he's suing the union for giving him bad advice because his union representative was there. So presumably he's arguing breach of duty to him. So he's arguing some basically breach of fiduciary duty. He's arguing his union reps were under an obligation to give him good advice and did not give him good advice. And so he's suing essentially for breach of fiduciary duty. You know, breach of obligation to him would be his claim against the union. Hank then sued. He brought claims against both Great Lakes and the union in the course of common pleas. Most of the claims were under Ohio law, disability and age discrimination, along with worker compensation claims. The one federal claim was count 4, which labeled a company breach of collective bargaining agreement. Defendants then removed the case to the Northern District of Ohio, which had federal question jurisdiction under a section of the act. So basically what happened here is one of his causes of action was a federal cause of action. So that means it's a subject matter of a federal court. So they removed it, which means take it out of state court and in federal court. Because he gave a federal cause of action, that means the federal court has jurisdiction over the whole case. So they removed it to federal court. So yeah, you got to make your complaint, but you put in a federal cause of action. You gave subject matter jurisdiction to a federal court, so they removed it. Fine, no problem. That's something they have the right to do. On July 17, 2018, the court granted summary judgment in favor of Great Lakes. It found that Hark was barred from raising any claims because he knowingly and voluntarily signed the release, which makes sense. That is what you would typically expect. But that exactly goes to one of the arguments you'd be making as a trial lawyer. You'd be arguing exactly against that. You'd be arguing it wasn't knowing, it wasn't voluntary. And, you know, because it was coerced, because of the time, because of things. There's arguments to be made here. It's not impossible, but it's difficult because there's a signed waiver. One of the reasons not to sign the waiver in the first place. But yeah, so the court found it was knowing and voluntary. That's basically the factual predicate. Is it knowing and voluntary or not? The trial court said yes. Okay. A few months later, the court also granted a summary judgment in favor of the union, dismissing the federal claim. It found that Lakes had not breached the collective bargaining agreement and the union had not breached its duty of fair representation. We gave you good advice. Fine. The court then declined to exercise its continuing supplemental jurisdiction over the remaining claims. So yeah, so the court said, okay, I'm dismissing your federal claim. Now, under supplemental jurisdiction, I can keep the case if I want, but I don't want to. So I've dismissed your federal cause of action. That's res judicata. That claim is gone. If you still have causes of action, go back to state court. I'm not interested in hearing this case anymore. I could do it. I just don't want to. Go back to state court. No problem. You can do that. Hank then files the appeal challenging the grant of the summary judgment. Great. We grant the review de novo. That is from the beginning. We look at the facts most favorable to the non-moving party. Great Lakes succeeded on its motion for summary judgment because the district court found that the claims were barred by the release. Accordingly, our review of the claims is limited to one question. Can the release be validly enforced against Hank? Hank's gives us several reasons why no. The release was illegally waives non-waivable rights. Okay. The release is not supported by consideration, which is definitely not true. It was. And Hank did not sign the release knowingly and voluntary. That's a better argument. But we find each of them without merit. Hank first contends the release is void ab initio, that is from the beginning, and it was never enforceable. So it was never enforceable in the first place because you made me waive things you couldn't make me waive. Great. As a general rule of law, in Ohio, personal rights can be waived. Waivers will be generally upheld as long as they do not violate public policy. Accordingly, a release waiving the right to bring legal claims is ordinarily an absolute bar to later action. Right. Hank signed a release saying he would not pursue a claim against Great Lakes. He brought several claims anyway, yet he does not point to a public policy declaring the claims non-waivable, nor are we aware of any such policy. Yeah, I'm not aware of any such policy that would make these non-waivable. There's nothing in statute that makes them non-waivable. There's nothing that I'm aware of that says this is a non-waivable right by law or by case precedent, so they are waivable rights. This seems like a loser argument, and the Court of Appeals agrees with me that it's a loser argument. Fine. But Hank charts a different course. Instead of arguing his claims in this case were not waivable, he argues the release is worded so generally it could be applied to waive claims that are in fact non-waivable as a matter of public policy. No, it's going to be fact specific. Even if theoretically the waiver could violate rights that violate public policy, do you have any of them? If you don't have any of them, who cares? So that doesn't work. Specifically argues he could apply to bar claims for unemployment benefits and claims arising out of future discrimination. And because the release could be read to waive certain non-waivable claims, the release is void. In other words, because the release could conceivably be applied in a way that's illegal, it's illegal. No. This is fact specific. No. Yes, the release is broadly worded. It's written to be broadly worded. Yes, it's meant to cover everything. The question is whether or not you have specific things that are covered or not. Do you have any facts of any of the things that were just mentioned? If not, go away. That seems legally correct, so I agree with the court. From the case law, we can extract a simple rule. A generally worded release can bar claims that are waivable, but it cannot bar claims that are not waivable. Right. A broad release will waive claims that can be waived. It will not waive claims that cannot be waived. Makes sense. A general release is not void on its face. Rather, its enforceability depends on the claim. Right. If we reject this rule and instead adopt the position, then practically every general worded release would be facially voided. Yeah, we can't do that. So that's not going to work. It depends on the facts. You don't have any facts. Go away. Hank next contends that release is invalid for lack of consideration. According to them, there was consideration. Great Lakes would grant layoff status instead of firing him, and in turn they would release claims. Yeah, I tend to think that this is consideration. Consideration is anything that a party's not otherwise legally obligated to do. Any sort of thing that you're not obligated to do. Great Lakes was not under an obligation to put him under layoff status. They could have fired him for cause. That's something they weren't obligated to do. And in turn, he's giving up rights he didn't have to do. He wasn't obligated to do that. Both parties are giving up something they didn't have to give up. That's consideration. No problem. Hank, however, argues this is a problem and is insufficient. His theory boils down to 5 arguments. Granting the right to file unemployment benefits is not consideration because he already had the statutory right to file. No. The exact consideration was not recited in the contract. Doesn't matter. Granting layoff status is insufficient consideration because he's going to be laid off anyway. No, they're going to fire you for cause. Hank signed the release under duress. That doesn't deal with consideration. And there's mutual mistake of fact over whether they could prevent him. No, there wasn't. We find each of these arguments unavailing, as do I. The court says forbearance from exercising a legal right is sufficient consideration. Yes, it's anything you did have to do or didn't have to do. If you're legally obligated to do it or legally obligated to not do it, it doesn't count as consideration. If you have to do it or have to not do it, it's not consideration. But if you don't have to do it or you don't have to do it, then it is consideration. Anything you didn't have to do or do have to do, yeah. So is it your discretion or not? If it's discretionary, then it's consideration. Great. Ewam says that in his country, if you're fired, you don't get unemployment benefits would be wrong in the first place in his country. Fair enough. I take note of that as it applies to European law. If that's true, if you're fired for cause, you still get unemployment benefits, then okay. This is a matter of U.S. law. Under U.S. law, if you're fired for cause, you don't get unemployment benefits. If you're fired not for cause, you do get unemployment benefits. So if that's not true in European law, I take note of it. Hank argues his signed release was under duress. He again signs no authority for this argument. Under Ohio law, to succeed on a claim of duress, plaintiffs need to show they are subject to wrongful or unlawful action that deprive them of unfettered will. It's generally not wrongful or unlawful if the defendant threatens to do something they're legally entitled to do. So yes, it is not duress if they're threatening you with something that they are legally allowed to do. That's not duress. That's not illegal. If my threat to you is something I'm legally allowed to do, I'm legally allowed to do it. And so it's not duress. It's not extortion. It's not blackmail. It's only extortion, blackmail, duress if I can't legally do it. If I can legally do it, it's not because I have a legal right. I'm just simply saying, here's something I legally have the right to do. Would you like to make a deal to prevent me from legally doing it. Yeah. So generally speaking, broadly speaking, because there are exceptions to this rule, so I don't want you to go off and assume that this is absolute. But as a general proposition, if you have a legal right to do something, it is not considered duress, extortion, or blackmail to threaten to do it. But that's only generally. There are exceptions to that rule, as there are many times in law. So consult a lawyer before you go off. So there's your tip for the day. In one final challenge to the release, Hank argues that he did not sign the release knowingly and voluntarily. This, I think, is his best line of argument, based on what I see. So let's see what the court says. We assume, as the district court did, that the 5-part knowing and voluntary standard is applicable for assessing whether the waiver is valid. And like the district court, we conclude that it was signed voluntarily. Under the Sixth Circuit precedent, courts looked at 5 factors: plaintiff experience, background, and education, the amount of time you had to consider waiver, including whether you had an opportunity to consult with a lawyer. That's pretty critical. The clarity of the waiver, how clear is it? That's important. Consideration for the waiver, which is the bargain for consideration. That's not really a factor here, although it might be if it's grossly disproportionate. And the totality of circumstances. Yeah, that seems about right. First, Hank has sufficient experience, background, education. He's a 49-year-old man with a GED, post-high school level proficiency in reading and word comprehension, and high school level spelling skills. On the first factor, Hank argues lack of business or legal experience, but courts have upheld releases signed by plaintiffs with even less experience. For example, as the district court noted, the court upheld a release even though, like plaintiff, he has only the equivalent of a high school diploma and no business or legal experience, and English was not the first language. Although they attempt to distinguish on other bases, he does not dispute that the plaintiff there had even less education and less English comprehension skills. Indeed, he points to cases where the court upheld a release as knowing and voluntary where they were more qualified. These cases demonstrate what could qualify as sufficient levels, but nothing in the cases establishes a minimum level. Fair enough. Second is the amount of time considered in the waiver, including whether he had an opportunity. Hank argues that Great Lakes never informed him that he could take additional time, but Great Lakes doesn't need to do so. Factor 2 weighs in favor of finding of knowing and voluntary if the plaintiff simply does not request more time, either to waive. So the question is, did you request it? And if they say no, then you're there. So can I have more time? Can I consult with a lawyer? If they say no, you have to decide right now, that would go into not voluntary knowingly. But he didn't ask, and they don't have to inform him. They're not the government. They don't have to inform you about your rights. So you had to ask, and you didn't ask. So that's your fault. Third is clarity of the waiver. The district court concluded, and we agree, that the release was written in plain English and only 1 paragraph long. It's entirely subject to someone to understand. There's no technical, legal, or business jargon, and made the term of bargains clear. I agree. It's a pretty clear agreement. It's not very complicated, and he had a union representative to explain it to him if he wanted to. It's very, very clear on its face. Not complicated, no jargon. Should be easily understood. Fourth is consideration. We discussed that. There's plenty of consideration. Finally, the court may consider totality of circumstances, meaning anything else. Hank does not cite anything else, and therefore there is nothing else. Fair enough. Therefore, it's knowing and voluntary. I tend to agree with the Court of Appeals conclusion, and the district court conclusion, based on the facts, is knowing and voluntary. Yeah. Hank also claims that his termination violated the collective bargaining agreement because it was in retaliation for filing a worker compensation claim. However, we agree with the district court that Hank has not produced any evidence to make out prima facie case of retaliation beyond his own conclusory statements. Therefore, his retaliation claims there's no evidence of retaliation. Because we find there's no breach of contract, we need not address the question of whether it breached the duty of fair representation, and for these reasons, we affirm. So that is the decision from the Court of Appeals for the Sixth Circuit of Stephen Hank versus Great Lakes. First of all, I agree with the court that there were no strong claims really here, but there were some arguments that were better than others, including the voluntary aspects. I don't know if it was winnable, but I think that was better probably to focus on the knowing and voluntary aspect of it. And there is even some stuff potentially with the duty of fair representation from the union that are workable. But the problem here is that he brought too many claims, too many stuff that's so weak. And so this is more about the practice tip than the substantive argument. Basically, come forward with your strongest arguments. It's up to the lawyer to figure out what those are and only come forward with those. Because you brought 27 allegations of error, the Court of Appeals basically lost interest because they found so many of them weak and they don't really care about the rest of them. So you should have brought only the stronger stuff. You didn't do that. And so this is much a practice tip as it is valuable for the substance. So I hope you found it valuable from that aspect. And that is the end of this case.